I want to include this little bit from Bartz v. Anthropic. Anthropic are the people who made Claude AI. The judges sent out some very interesting questions. So here's some questions that Judge William Alsup has for both sides, and this is a really great method of doing it, where you ask questions and you go step by step. Where does fair use end and copyright infringement begin? So what he's going to do here is pin them down. Notice he's not asking where they think things should be, but to what extent each of the following cases does or does not violate copyright law. So he's asking for their opinion about the current law. Case 1. An ebook is purchased at full price and read over 5 days by the purchaser. Each day he reloads the entire book. There are those who would want this to be kind of a subscription service where every time you load it up, you'd have to pay for it again. But that's not the way it currently is. And they're pretty much yes or no questions. Yes, this is. No, this isn't. This is fine. This is infringing. And by the way, make no mistake, these may be named individual authors as plaintiffs. They're really acting on behalf of the big publishers and the Authors Guild. That's who's really behind all of this. They're trying to make it look like it's the little guy versus these big corporations. It's the other way around. Plaintiffs assume that this purchase is from an authorized legitimate retailer. Plaintiffs assume that reloading the entire ebook refers to re-downloading it from the retailer, and in so doing, the person is not violating any of the ebook's digital rights management or license. He's not bypassing the DRM, even though the courts have said you can do that for personal use. If these hold, then the purchaser has violated neither copyright law nor any license. They're not actually answering the question. This is simple yes or no. You've got a guy who's bought a book and he's reading the book that he's purchased. That should be an overwhelming non-infringing. That shouldn't even be hesitating. You shouldn't need all these words for that. The fact that they're doing all this to try and talk around it and trying to make it more nuanced than it really is, that tells you what they're up to. Case 2, same as case 1, but he buys the ebook for 1 cent from a notorious counterfeiter known as Books Are Cheap. This is paid piracy. Okay, yes. And Anthropic, if you remember, are the makers of Claude AI. And here you're actually going to see straight answers. And they say, Anthropic agrees with plaintiffs that, on their assumptions in case 1, the purchaser does not infringe, and in case 2, he does. Now here's where things get interesting. Case 3, same as case 2, but his purpose throughout is to write a transformative parody of the work, and he does. And they say the initial acquisition from a counterfeiter is infringement. The purchaser's subsequent actions are irrelevant. There it is, right there. Fair use is destroyed. And again, they're pointing to Warhol. That's what they want. They want fair use to be destroyed, and they want to be able to grind you under the heel of the big publishing cartels. And they've done a lot of that since the DMCA came out. They've added on a lot of extra crap to try and do it. They're saying it right here, loud and clear. That's what they want. And they say it straight out. This is fair use. Parody is a quintessential fair use. That is the answer, straight and direct. Imagine having to get permission from the people you want to lampoon. No precedent counsels a different result here. So the parodist's unauthorized back-end copies are also fair use. If the use is otherwise fair, then no permission need be sought or granted. That is why the Supreme Court has rejected the idea that bad faith has any role in a fair use analysis, concluding that its previous skepticism about this was justifiable because copyright is not a privilege reserved for the well-behaved. And yet on the socials, that's completely what we're assaulted with. By all these lying authors who want to take away your rights. Because they want they don't even want the power. They want the publishers to have the power. I don't know if they even realize that. They probably think that they're getting the power. They're not. It's going to be the big publishers. But that's why this is so important. By contrast, Books Are Cheap commits copyright infringement by enabling and profiting from unauthorized distribution of ebooks for its purchaser's consumptive process. Yeah. Go after Books Are Cheap. Don't go after the parodist. Case 4, same as case 3, but his purpose further includes to write the parody with co-writers, so he buys one ebook and copies it for all co-writers. So he does buy the book, but he gives his collaborators a copy of it. But what they're all working on is parody, it's a transformative use, it's fair use, it should be allowed. And this is exactly the kind of thing they're trying to destroy. They want to say that no matter what, you have to get permission from them. You have to get a license from them in order to do a parody. And they say the distribution to the co-writers for purpose of their common enterprise could also be an infringing act not excused by fair use. You see? The fact that they're using it jointly to write a parody, which is absolutely transformative, which is absolutely fair use, does not count. Which means there is no fair use. Because then you could just say, you're not allowed to do any parodies of my work, and you cut off parodies at the knees. Or going back to the film critic example, you're not allowed to use any of the clips from our movie, and then you can't do your movie review. Well, you can, but it's not going to be as effective because you can't show the clips you're talking about. So the only ones who could do the clips would be from the ones who review their movies favorably. That's it. That's complete and utter destruction of fair use. But nope, the defendants give you the straight answer. This is also fair use. That's what Judge Alsup was doing. He knew he was writing questions that had these straightforward answers to it. And I think probably what he wanted was to see who was going to give him those straight answers and who was going to try to talk around it. Straight answers here from the defendants. Again, the means by which each parodist obtains a copy of a copyrighted work does not affect their fair use. What matters is the purpose for which that copy was made, and I love the fact that they're throwing Warhol back against them. Because we said that's how dumb of a ruling that was, and they really need to clarify that. And maybe they will in these cases eventually make it up to them. But yeah, like I said, the plaintiffs relying on Warhol is just a joke. In case 5, someone buys a copy of the ebook at full price and then gives it to a writer who uses it to write a transformative parody of the work. Should be the same thing. Should all be fair use. And they say if the gift involves making an unlicensed copy of the ebook, that will be an infringing act subject to a fair use analysis. That's not answering the question either. They're asking you what the result of the fair use analysis should be, not that it's subject to it. They say the legality would depend on the outcome. The judge told you the outcome. Writing a transformative parody. See how they have to avoid the question? No. Defendant said this is likewise fair use. It is irrelevant that the parodist did not himself purchase a copy of the work. What matters is the purpose of the copy. And a variant, for any case relevant or for all at once, briefly explain to what extent it makes any difference for the copyright laws whether the work is purchased as an ebook or instead in print and converted by the purchaser immediately into a digital format before the next step. And that's another big thing too. Oh, you digitized the book. You transferred it to another format. We had to deal with this crap back in the day. We had a record and we played our records on record players. We had our cassette tape players. We wanted to listen to our legally purchased record players on the cassette, so we'd copy it over. We'd play the record, hit record and play on the tape, copy it over to a blank tape, and have it with us. And they were like, you can't do that. You can't transfer it over to another medium. You need to buy from us again. Buy it from us again and again and again and again. Buy the album, buy the cassette, buy the CD, buy the super duper ultra remastered CD. I don't know. How many times can you buy Dark Side of the Moon? They just keep making money off of that album. This coda specifies that the physical book purchaser immediately converts the physical book to a digital format. That is a prima facie infringing act under the statute, and the digital copy is no longer subject to a first sale defense. There you go. 40 years of precedent, 40 years of consumer protections erased in a moment if they have their way. That's what they want, right from the horse's mouth. But the defendants say nothing in fair use doctrine suggests the format of the original work should have any effect on the outcome of the fair use analysis. These should have been straightforward. These should have been straightforward. And they couldn't do it. And so I guess we'll have to see what Judge Alsup is going to do with this, because he knows that there are simple answers to these questions. He just wanted to see what they were going to do.